What it do, American government students? Finian is sleeping right now, and I got home. I didn't have a prep last couple days, so I apologize for the delay here. I'm gonna make you a review video, and I'm pretty much just gonna go through the review guide. So, again, like I've always said, if you want a laundry list of terms and the vocab that you need to know, check out the unit cover sheet. It's got everything there, broken down by topic. There's 3 topics in this unit, as per usual, and then these are the different things that different handouts we have had so far this unit that make up your study packet. Free speech cheat sheet was like a little half sheet of paper that I made for you guys as a scaffolding for to help out with free speech cases. So here's the big deal: there will be a retake opportunity for the topic 1 quiz. Make sure you know what you got on that because you don't need to do it again if you already did fine on it. Topic 2 is about civil liberties. So here's how it's going to work. There's going to be some multiple choice, and then there will be 3 choices that you can choose from because that is why they're choices. One will be a free speech, one will be a free religion, and one will be a search and seizure. So for a 3.0, 95% proficient, you just got to be able to analyze one of them correctly. For a 4.0, 100%, you got to be able to do 2. If you do all 3, I'm just going to grade the first 2 because I grade them by question. So it doesn't really help you that way. So do the ones you feel the most confident with based on the situation. But I'll go through these ones quickly, and then we'll talk about civil rights, and then we'll go from there. So key thing here, don't forget you have the free speech cheat sheet, which looks like this. This goes through how do you think about it. The first thing is always, is the restriction being done by the government? Because if it's not, it doesn't violate the state action doctrine, which means the Bill of Rights only protects you from government intrusion on your liberties. So let's go on here. This one is First Amendment free speech restriction. A city passes an ordinance prohibiting demonstrations in the downtown plaza without a permit. The permit application requires a 30-day advance notice and a payment of a $500 fee. During a rapidly developing political situation, a group of citizens gather spontaneously in the plaza to protest. Police officers disperse the crowd and issue citations. The protesters claim this violates their First Amendment rights to free speech and assembly. Was this ordinance unconstitutional under the First Amendment? And we want to explain using specific things. So, here's what we got here. Where are we at? So, free speech. Let's just walk through what it says on the cheat sheet for us. So it is by the government. So first thing we have to think about it is the restriction content-based, which means restricting a specific topic or viewpoint, or content neutral. Well, the law says that any public demonstration needs to have this permit and 30 days advance notice. So this doesn't say it's specific to political protests or any type of protest content. It could be a Girl Scout parade for all we care. Okay, so it's content neutral. So this has to meet intermediate scrutiny. It's not content based, so we don't really have a ton of information now because it could go. It's basically even on the balancing test between the government and the individual here. Does the speech fall under an unprotected type of speech? So it's not obscenity, it's not defamation, it's not inciting legal activity, it's not student speech at school. So basically, this doesn't really apply in this situation. And the last thing is, it is a demonstration. It's demonstrations, gatherings on public property. So we have to think about, are there time, place, and manner restrictions? Remember, we already have defined that this is content neutral. So is this a public forum, which means it's always open for speech and gathering? I would argue that it is. It's a public forum. It's not limited. It's not shut down sometimes. And it's not closed. It's not closed off. It's an open public square or public, I forget what I called it in this situation, but it's open to the public. That means that it's always open for speech and gathering. That means they could put time, place, and manner restrictions on it, but they have to be reasonable and content neutral. Well, we already went up here and we said it is content neutral. So it checks that box. The next question is it reasonable? Are these reasonable time, place, and manner restrictions? So this is kind of what it hinges on. And this is kind of where it's up to interpretation. And this is sometimes there's not a right answer. This isn't a real Supreme Court case. So we do say it's content neutral. Okay. So that requires intermediate scrutiny generally. It is not an unprotected type of speech. Excuse me. And it's a public forum, which means time, place, and manner restrictions could apply as long as they are content neutral, which they are. and reasonable. So here in this situation, the right answer is truly, it really depends on what is considered reasonable by the courts. So they might look at precedent cases or other ordinances in the same area, or what the potentially what the issue was that was happening, that was spontaneously in the plaza to protest. And they would try to think about, is 30 days really a reasonable amount of notice, especially if you have a political protest, because a political protest usually happens in pretty short notice because something happens and people want to protest it. They don't usually wait a month. $500 fee is kind of a lot for being in a public area as well. So my guess would be that this would be considered an unreasonable restriction overall, but it's really intermediate scrutiny. It could go either way because it's content neutral and it's in a public forum where time, place, and manner applies. So that's kind of how we want to break it down. This is all about breaking down thinking patterns and frameworks and just being able to use them in different examples. A lot of people do not understand how to do this, and it kind of clouds up people's political conversation. So just being able to work through the thinking pattern is a big deal and is really helpful. First Amendment Establishment Clause test. So this is going to be the Lemon test. So we got to remember what the Lemon test is. So once again, this is just on the slides, but the Lemon test has 3 prongs, and it's for, is the government promoting a religion? The first is, does it have a secular purpose, which means non-religious, typically a purpose by the government? The second question is, does the policy promote or inhibit religion? And we use 2 different things. We use sorry, no, I'm blanking on it, but the coercion test and the geez, I can't remember what it was. Coercion test and the other test, which basically the second test is basically, would a reasonable observer think that it's promoting religion? I think it's a rational observer test or something like that. I apologize, but that's what it means. And then does it create excessive entanglement, which means it's kind of difficult to figure out where the government side interest ends and the religious interest begins, or they would cause a conflict of interest or something. So let's check this out. Small town uses public funds. Okay, so that's where the issue is. It's using money, public money, to erect a large religious monument on the lawn of the county courthouse. The monument includes inscriptions from religious texts and is dedicated to the quote-unquote glory of God. Town officials hold a formal dedication ceremony with prayers led by local clergy. A resident challenges this as a violation of the Establishment Clause. Use the Lemon test to explain the situation. Okay, so does it have a secular purpose that's non-religious? Honestly, I'm going to start here and be like, I'm not really sure it has a secular purpose. I mean, maybe to beautify the county courthouse, but that's not going to meet strict scrutiny. That's not a compelling interest. It's not the least restrictive. So maybe rationally, potentially, we could say there is. But I would say we might need to be able to strike it down right there because that's kind of difficult. Does the policy promote or inhibit religion? So the coercion test has the resources of the state, has machinery, as they call it, of the state or the government, been used to promote religion? I would argue yes. In this case, it kind of has. It's got, they're erecting a religious monument. It's got religious texts. It's not like a historical thing that represents, and it doesn't have a lot of diversity and representing a lot of different religions. It says to the glory of God. It's kind of basically, you could maybe argue God is kind of vague, but having a monotheistic religion kind of harkens back to either Islam, Christianity, or Judaism. So also they have a dedication ceremony with prayers by local clergy. So it is definitely showing that the machinery of the state is being used to promote religion. So already I think we can kind of say this violates the Establishment Clause just based on that. Does it create excessive entanglement? Well, if we say it doesn't have a secular purpose and it doesn't pass the coercion test, then we could say, yes, there is entanglement. It's kind of difficult if you were a passing observer to understand where the government ends in this situation and where the religion begins and vice versa. So there's definitely interest. Also, if they're using these public funds and they're maintaining this in front of the courthouse, that could cause some conflicts of interest as well. So I think here our overarching conclusion is this is a violation of the Establishment Clause. Now, if it was donated and it was part of like several different religions and there wasn't like a big ceremony to dedicate it and there weren't inviting local clergy and all of that, that might be a little bit different. But I think based on this situation, we can say yes. We'll do a quick time check here just to make sure. Got about 5 minutes. Oh man, this is rough. I might have to do a separate one for the equal rights. Okay, Fourth Amendment. I got here right here, so we can do this already. This is what we've got. So after receiving a tip from a confidential informant about possible illegal activity, police enter a person's backyard without a warrant, look through their garbage bins. Okay, so already I'm thinking, where is this on their property? This is what we call the curtilage. So you can go back. Curtilage is kind of represented as having an expectation of privacy that usually needs a warrant. Based on the evidence found there, they obtain a warrant. So they did obtain a warrant. This isn't a search without a warrant. So that bodes well for them, I guess. During the house search, they discover evidence used to charge the homeowner with a crime. The defendant's attorney files a motion to suppress the evidence, claiming the initial search violated 14th Amendment or 4th Amendment, protections against search and seizure. So here's what we know. Was it by the government? Yes, the police did it. Was there an expected area of privacy? Well, yeah. I mean, it's their home or around their home, and they're challenging it. So we know, yes, that would be right. So then the question is, was the expectation of privacy reasonable and legitimate? And I would say in this case, yes. The initial search, although it was of the trash, was placed in the curtilage or on the curtilage of the house. Okay. And the police entered without a warrant. And then the other thing we have to think about is none of the other evidence would have been gathered without this illegal search. So that would be another issue as well. So again, it's a tip from a confidential informant. That's not enough to enter someone's curtilage without a warrant. You could potentially try to get a warrant and persuade a judge you have enough information to do that search at that time. But if you don't, then you probably don't have enough reason to go into the curtilage. So again, that's the issue of like the main places we talked about was the house, the curtilage, the area, your yard, the area around a public field. And we also discussed vehicles and cars. Okay, I'm going to stop this one here. This is on topic 2. I'm going to do one on topic 3 quick, which will just be this case study right here. Okay. Actually, I could probably do it. I'm going to try to do it in 2 minutes, 45 seconds. So, all right. So again, we have to look at, this is about levels of scrutiny specifically. So Loving v. Virginia, 1958, 2 residents of Virginia, Mildred Jeter and a black woman, Richard Loving, a white man, were married in the District of Columbia. The Lovings returned to Virginia shortly thereafter. The couple was then charged with violating anti-miscegenation, which is basically banning interracial marriages. So the question is does the restriction on interracial marriage law violate Equal Protection Clause of the 14th Amendment? Now we have to think about what is the discrimination. This is not marital status. They're not saying married people versus unmarried people. So what is the groups or the separation of groups? And this is by race. This is saying that people of different races can't get married, but people of the same race can get married. And then we would say, what level of scrutiny? Well, because it's race, I can already go back to this chart here, and I can tell you that it's going to be strict scrutiny. So I have the chart here, okay? Strict scrutiny, which means that they need to show that they have a compelling state interest in stopping African Americans and white Americans from getting married. And there's no whatever that compelling interest is, there's no least restrictive alternative to doing this. So strict, and then they said show a compelling state interest with no less restrictive way. And I can limitation or yeah. So basically they would hear this would not, you don't have to ask about that, but this would not be upheld. This was 9-0 decision right around the time of Brown v. Board of Education. Civil Rights Acts, Voting Rights Act, they said this is not serving a compelling state interest and it is not the least restrictive way of doing so. So that one would be turned down. A lot of racial discrimination pretty much all the time is going to be turned down unless it serves a compelling state interest, which is very hard to prove. And the limitation or the restriction cannot be less restrictive. It's very narrowly tailored. So that's kind of how we work through these. Again, these are just thinking patterns and just thinking through things constitutionally and how they work and analyzing situations. So if you have any questions, let me know. Otherwise, please subscribe to my YouTube channel. Smash that like button. Keep those likes higher than those dislikes.